It now takes over a year to have an appeal heard by the Minnesota Supreme Court. There are just too many cases to handle properly. In fact, if something is not done now, a majority of Minnesotans may find they will be denied the right to appeal. But there is a solution. November 2nd, vote yes on the constitutional amendment.
There are many things that make Minnesota a great place to live. Let's make our court system one of them. November 2nd, vote yes on the State Appeals Court Amendment and get a court system that does Minnesota justice. Does Minnesota justice. Does Minnesota justice. That does Minnesota justice. Does Minnesota justice. Minnesota justice.
(1858). Minnesota becomes the 32nd state in the Union. In that same year, the Minnesota Constitution establishes the judiciary as the third branch of state government. The Constitution sets up a system for providing justice to Minnesota citizens, many trial courts around the state, and one Supreme Court to hear appeals from those courts. For nearly 125 years, the Supreme Court manages the volume of appeals coming from the lower courts. But in the 1960s and 70s, the number of appeals to the court explodes. In 1957, 213 cases are filed with the court. By the 1980s, filings approach 1,500 per year, far too many for the court to handle properly. Robert Sharon, Chief Justice of the Supreme Court in 1981.
The increased volume of cases coming to our court made it increasingly difficult for us to give the attention to the individual case that we felt that we should give to it. We did our best, but there were times when we had to give short shrift to some of the cases, and that was troublesome.
The first half a dozen appeals that I handled in the late 70s, I got oral argument, but by the 80s, you'd file an appeal and nothing would happen for the longest time, and then out of nowhere you would get, without oral argument, a one-line decision. The Supreme Court simply didn't have the resources to write opinions in every case that it decided.
We are a common law-based system of law in this country, and so the decision is important not only to resolve the dispute in the immediate case, but also to guide the public and lawyers on the resolution of other cases in the future.
There was a real danger that things were going to deteriorate if they didn't get some kind of system that would enable them to spend the time and thoughtfulness and effort that they needed on the significant cases.
July 1980. Doug Amdahl, a longtime district court judge, takes the oath to become an Associate Justice of the Minnesota Supreme Court. A few months later, he considers resigning.
It was an honor to be on the court, but it was an honor that was gradually wearing off because you were so busy that all the time that you really couldn't do anything else. Judge Simonette joined shortly after I did. And one day I remember coming out of the conference room and he tapped me on the shoulder and he says, "Doug, you ever feel like we're living on the edge of panic?" And that's just the way the court was. We'd reached the breaking point.
A crisis in Minnesota's judicial system threatens, one that imperils the judiciary's core mission to provide justice to the people of Minnesota. Minnesota citizens must come together to resolve the crisis and protect the quality of justice in their state. December 1981. Robert Sharon retires from his position as Chief Justice of the Minnesota Supreme Court. Doug Amdahl becomes the new Chief Justice. The court is at a breaking point. Amdahl knows that something must be done. He takes his concerns to the people of Minnesota.
The need for action is no longer debatable. If we're going to maintain the position that everyone is entitled to one appeal, something has to be done in order to maintain that. We can no longer do it with just the Supreme Court.
Sir Henson. Mr. Chairman, members of the committee, Senate File 1669 proposes a constitutional amendment to establish an intermediate court of appeals. The workload of the Supreme Court is increased dramatically.
I had a little concern about the delay that the intermediate court would produce. So I pressed for consideration of the New York system where the 3 district judges would become the appeals court. I held it off for 1 calendar year, and no one was buying into that. We certainly need some intermediate appellate procedure, and so then I was helpful from then on.
Senator Hansen moves that the bill as amended be recommended to pass. Further discussion? No further discussion. All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried.
Thank you, Mr. Chairman.
March 22, 1982. Governor Quee signs legislation putting the constitutional question for a court of appeals on the ballot that next November. Now it is up to Amdahl and his supporters to persuade Minnesota voters.
Of course, constitutional amendments need a majority of persons voting in the election to vote for it. So a voter who doesn't vote on that issue is a no vote. So the concern was to get public educated.
I wanted 1,000 speakers making the same speech in 1,000 different places. We never quite reached that, but we didn't come too far away from it either.
You know, every project of this magnitude needs a champion. You need a leader, and Doug Amdahl took that role, grabbed it by both hands, and carried the whole project along. He was the one who was willing to go anywhere, speak to anybody, any group, and continually carry a consistent message about why we needed a court and how it would look.
I spoke in every place in the state, I think. I still remember one of the bar leaders said, where 2 or 3 are gathered, Amdahl's there selling the Court of Appeals.
Amdahl formed a large coalition of supporters, including both candidates for governor.
Wheelock Whitney, Rudy, these diverse people and organizations are united on one point. They agree that Minnesota's courts must be improved. Join these people and vote yes November 2nd on the State Appeals Court Amendment and get a court system that does Minnesota justice.
But not everyone supported a court of appeals.
Opponents of the Court of Appeals thought that it would just be another layer of bureaucracy, that it would be simply one more step in the process before you got to a real court, the real Supreme Court, to get a definitive answer.
Of course, there were the political aspects of it, too. The governor appointed those first members of that bench.
Former Governor Harold Levander strongly objected to the new court.
He did not like the idea that if you had the Court of Appeals constituted, you would have the governor of one party appointing all the judges to the court. So he was quite vocal in his opposition, and I can remember him at bar meetings speaking as if we didn't need the Court of Appeals.
There were a lot of people that thought it'd be expensive, it would delay justice, it would, what would be the quality, and so on. Just as any change, there was widespread questioning of what the effect an intermediate court would have in the practice of law.
Shortly before the November vote, an election judge told Amdahl a story.
Our biggest problem with constitutional amendments was that they were in lower left-hand corner, upper right-hand corner always of the ballot. So people who were just looking at the main ballot didn't pay any attention to these things. This lady got up and said, Judge Amdahl, we 1 year told everybody to be sure to look for the constitutional amendments. 80% of the people voted then on the constitutional amendments. When I got back home that night, it must have been about midnight, I got one judge out of bed in every judicial district of the state. I said, you get down to your county auditor. I knew the county auditor is going to have the election judges in for an educational program. You get down to your county auditor tomorrow and tell them to be sure to tell the election judges, to tell the voters to look for the constitutional amendments. Well, it worked so well, not only did my constitutional amendment, the Court of Appeals pass, railroad bonding passed, horse racing passed, and then there was another one, but that year everything passed.
In the final analysis, it was the voters of Minnesota, 80%, I believe, of those who voted on the issue of whether to change the Constitution to allow for the creation of the court. But he worked night and day on it, and it was his drive, imagination, and ability that pulled it together.
He could be described as the architect, the parent, the quarterback, the relentless, tireless advocate for the court. No one had anywhere close to the role that he played in the creation of the court.
Spring 1983. Peter Popovich, a St. Paul attorney and former legislator, receives an early morning call from the new governor, Rudy Perpich.
So I said, what can I do for you? And he said, well, Chief Justice Amdahl, we won the election in November, and now it says we better get going. This was May. Court's going to go into operation in November. And he said, I would like you to become the first chief judge of that court. And here's a real challenge, Practiced law for a number of years, to be able to help get a new court going would really be fine. So I called the governor back and said, okay. I then, 10 minutes later, got a call from the Chief Justice. So we started to talk about things too. We had to get quarters, we had to hire people, we had to get announcements out.
We tried to set up processes that would be really efficient. Peter had gone to NYU, the appellate judges school.
I'd have dinner or lunch or breakfast with different judges, and I'd ask them all the same question. What's wrong with your system? What's good about it? What would you do different? Put yourself in my shoes. You got $2 million available. There are going to be 12 judges. We have no room, no quarters, nothing.
I might say other states were very helpful. Wisconsin and Michigan went out of their way to help us, to give us examples, tell us what to expect.
Minnesota was late to establish an intermediate court of appeals. We were about the 35th state to do so. So we had the benefit of other people's mistakes.
November 1983. The first 6 judges of the Court of Appeals are sworn in.
I think there was a mixture of anticipation, probably a little trepidation about the enormity of the task that we were undertaking. But there was a lot of exhilaration about being part of something that was new and that we'd have an opportunity to make some changes at a time when changes were deeply needed in the appellate structure in Minnesota.
The people who went on the court were thoroughly experienced people, and most of us had done quite a bit of trial work. It was sort of catch as catch can. We were all inventing, we tried to invent it beforehand. We weren't able to foresee it well enough.
We were ready, but it's one thing to be ready and another to see what's going to happen on the ground.
I argued one of the, in the first month of the Court of Appeals, it was an interesting experience because the court was in temporary quarters at the Landmark Center. And so you didn't have the majesty that usually attends appellate court arguments. But I'll give Chief Judge Popovich a lot of credit. You knew you were in a court, and you knew that it was formal and that there were rules, and you better follow them.
I think that we worked well collectively as a group. Peter and all of us relied very heavily on the knowledge about court procedures that Sue Sedgwick and Dan Foley and Ed Parker, as longtime district court judges, brought to the mix. I had had 5 years on the county court, and so we all brought an aspect of background experience.
We were putting in long hours. It couldn't be helped.
We knew very well that we were going to have stacks of cases. We knew that they were going to be coming at us on a regular basis, and that we had to act promptly, decide wisely, and keep moving.
Boy, were we glad to see the 6 more judges in the following spring.
So we came to the Court of Appeals expecting to work, and indeed we did. And of course, our court then from the beginning was really 4 courts. We had 4 panels of 3 judges each, and so we were able to handle a great deal, many more cases than the Supreme Court. From the filing of the notice of appeal to the day that the parties and the attorneys had our opinion in hand, that timeline was, I think, 6.5 months. For our non-oral cases that were not subject to oral argument, that timeline was 6 months. And we were very proud, and rightly so, I think, of that.
We were once introduced by the chief judge in Hennepin County, although it was a slip of the tongue. He meant to say the Intermediate Court of Appeals. He said the Immediate Court of Appeals.
Peter Popovich was legendary for the firmness with which he administered the court. We had this new document, the Statement of Case, that the court needed to have enough information to process the case efficiently. I remember getting a letter from Peter Popovich, and I learned later I wasn't alone, and the letter basically said, "Dear Eric, we've had to correct things in 3 of your appeals in the last 4 months, and we really don't expect to have to do that. Please shape up." Peter was tough.
Harold Levander, the chief opponent of the new court, spoke at a Bar Association meeting several years after the court went into operation.
And he said, well, you all know what my position was on the Court of Appeals. I didn't think it was necessary, and I didn't think it was functioned well. But I said, I want to stand up here in the presence of its first chief judge, Peter Popovich, and say that I changed my mind.
1987, Don Wozniak becomes the 2nd chief judge of the Court of Appeals when Peter Popovich is appointed to the Supreme Court.
Don's background as a legislator was very helpful to the court. Don was very resolute about going to the legislature and getting additional judges.
Important objective, and that is to provide our citizens with an efficient, inexpensive, and expeditious appeal process. Because you are well aware in setting up our court that justice delayed was justice denied.
I really loved my years on the Court of Appeals, and I had great colleagues. I found that they worked very hard, they took their job very seriously, but also is that they understood in order to function well as a court, a collegial court, they had to get along with each other, and they knew how to have fun with each other.
Ann Simonet was an absolutely terrific chief judge. She was good both with administrative issues and also very interested in jurisprudential issues. The great tragedy was that it was for such a very short time. Judge Toussaint has been our chief with the longest tenure and has brought wonderful qualities to the court. He leads by participation, and he's a great motivator in that way.
This job is such a spectacular place from my perspective. Not only do you get an opportunity to deal with all these various issues, but it's also related to the people that you work with on this 3-judge panel,
primarily, and helping to develop the law of the state. 95% or more of all cases that are appealed are resolved by this intermediate appellate court.
The Court of Appeals has a very significant job of in a way, filling in the gaps in the law that are left by broader Minnesota Supreme Court opinions.
One of the ads for the constitutional amendment has a little phrase in it that says, we need a court structure that will do Minnesota justice. And I think this court has done Minnesota justice by giving as much access as possible to litigants.
The Court of Appeals gives everyone the right to an appeal. In other words, you have a right from any decision on the district court to go to the Court of Appeals. So at least you'll be heard.
Please rise. The Minnesota Court of Appeals is now in session. Chief Judge Toussaint, Judge Galatowski, Judge Muehlberg. Chief Judge Toussaint is presiding.
Good morning. Please be seated. Well, Counsel, good morning. Welcome to the Court of Appeals. You each have 15 minutes to present your arguments and 5 minutes of rebuttal for appellant.
Thank you, Your Honor.
The authority of any court derives not just from the statutes and the Constitution, but from the trust that the public reposes in the court. And if you had a court that didn't explain what it was doing and wasn't visible in the decision-making process, you were going to have a court that didn't enjoy the trust and confidence of the public. Our court system rates at the highest possible measure for public trust and confidence. And that's in large part because of the transparency of the process that you get from written opinions and oral argument in every case. I've argued cases in lots of different jurisdictions across the country. It is really one of the finest intermediate appellate courts in the country.
I think that that the court has been very successful.
In a way, the system has not only been designed, but most specifically the way it's been implemented has been a model for other states.
It's really unthinkable how our system could operate without the Court of Appeals.
It's one of the most successful Court of Appeals in the United States.
The creation of the Court of Appeals really captures the spirit of Minnesota, the legislators, the judges, lawyers, citizens, and citizen groups. Once they perceived that there was a problem that needed to be addressed, everybody really came together to solve it. The people who've been on the court have tried to respond by doing the best job that we can. So we have a court system that works, that people expect it to work, and it does work.
Thank you.